Have you ever been at a pizza party where one person wants pepperoni and everybody else wants cheese pizza? That one person, the minority, gets outvoted by everybody else, the majority. And in theory, this works out. I mean, most people get what they want. But what if this applied on a countrywide scale? What would happen if the majority always got what they wanted and the minority never got what they wanted? Well, that would lead a lot of people to be pretty unhappy with the government, especially those in the minority. And you know what happens when people aren't happy with the government. But not only that, what if the majority suddenly decided that they wanted to take away the rights of the people in the minority? What if they decided they didn't want people in the minority to vote or to be able to express their thoughts and opinions? Luckily, the Founding Fathers realized that this could end up being a problem, and they included some safeguards in the Constitution to protect against it. Let's talk about the first one, the Bill of Rights. For those of you who aren't familiar with the Bill of Rights, it's the first 10 amendments to the United States Constitution, which enumerate specific protections for individual liberties and rights. Let's take a closer look at its provisions and how it compares to other countries without a similar enumerated list of rights. The first amendment that we'll talk about is the First Amendment. The First Amendment is pretty well known for freedom of speech, but it also encompasses things like freedom of the press, freedom of assembly, freedom of religion, and the right to petition the government. In doing so, it ensures the ability to express opinions, practice religion freely, and to challenge governmental actions. If you're part of a minority religion, it becomes incredibly important that the government is actually obligated to protect your rights, legally speaking. Minority religions usually don't have a lot of representation in the government, so that makes it a lot easier for members of the government to pass legislation or institute regulations that could infringe upon an individual's right to practice that religion. But because freedom of religion is part of the Constitution, it becomes a lot harder for governments to actually infringe upon that right. Recently, a lot of countries have come under fire for the practice of banning hijabs in schools and government buildings. That would be a lot harder to do in the United States because of that freedom of religion. Other countries may not have a single written constitution or a Bill of Rights. For example, the UK relies on a combination of statutes, common law, and conventions. Rights are listed out through documents, but not all of them, and not to the same degree that the United States does. It's also a lot easier to amend a law or make changes to legislation than it is to actually amend the Constitution, since that requires a lot of people to be on board. In fact, we've only had the Constitution amended 27 times. Think about fascist regimes and how they tend to take away freedom of speech for citizens. If you take away the ability of the political minority to speak their mind and express their opinions, then really you're just hurting democracy. It means that those in power will continue to stay in power, and anybody who voices a different opinion will get shut down. That's not quite how change is made, and it's a pretty bad way to run a country. But the Founding Fathers, again, thought about this, so they made sure to include freedom of speech, freedom of assembly, and freedom of press, so that we can have a functioning democracy that actually reflects what the people want. Therefore, the political minority are pretty much guaranteed a voice, as long as their speech doesn't create a clear and present danger, aka no yelling fire in a crowded theater. Let's go back to talking about other countries. For example, Australia doesn't have a Bill of Rights at the federal level, and that poses a problem for protecting minority rights. Instead of a Bill of Rights, the Australian Constitution does provide limited explicit rights, such as the right to trial by jury and protection for freedom of religion. But these rights are pretty narrow in scope and don't cover a lot of civil and political rights explicitly. So, rights are mainly protected through statutes and common law. Significant legislation that protect the rights of Australians includes the Racial Discrimination Act of 1975, the Sex Discrimination Act of 1984, the Age Discrimination Act of 2004, and the Disability Discrimination Act of 1992. Now, these laws do address specific areas of discrimination, but lack the comprehensive coverage of a Bill of Rights. Without a Bill of Rights, protections can be inconsistent and dependent on legislative activity. This could lead to gaps in protection, especially for emerging or less recognized minority groups. But additionally, statutory protections can be amended or repealed by a simple majority in Parliament. and that makes minority rights vulnerable to shifts in political power and public opinion. For example, if a new parliament came to Australia tomorrow and decided that they wanted to do away with the Age Discrimination Act, all they would have to do would be to get a simple majority. And that's tyranny of the majority if I've ever heard it. But like we said earlier, that's a lot harder to accomplish in the United States. If you tried to pass legislation that discriminates against someone based on age, the Supreme Court would probably say nuh-uh. And that brings me into my next point. The judicial branch is uniquely positioned to help minorities and actually be a last resort for people who believe that they've been wronged by the government. The principle of judicial review is not very common in other countries, but it's something that we've developed in the United States. Essentially means that the judicial branch can look at some of the laws passed by Congress and determine if they are actually compatible with the Constitution. If somebody brings a law forth and says, hey, this violates the Second Amendment, then the judicial branch actually has the right to say, you can't pass that law. And that's pretty cool. A lot of the key Supreme Court decisions have been to protect minorities, like Brown v. Board, which ended racial segregation and protected the rights of Black Americans. Another case was Obergefell v. Hodges, which established that same-sex marriage is a constitutional right. One of the key mechanisms for protection is the Equal Protection Clause. Equal Protection Clause is part of the 14th Amendment and mandates that no state shall deny any person within its jurisdiction the equal protection of the laws. This clause has been really powerful in protecting minority rights. Thanks, Founding Fathers. So not only does the principle of judicial review put the government in a very unique position to help minorities, there's one other feature of the federal courts that's important to know. Do you remember those recent hearings where they were deciding if Ketanji Brown Jackson should be a member of the Supreme Court? Well, they decided that she would, and she doesn't have to go anywhere for the rest of her life. When this idea of a life tenure on good behavior was first suggested, it was met with a lot of criticism. I mean, if judges got life tenure, then they could pretty much just get up on the bench and kind of do what they wanted. But Alexander Hamilton, in Federalist 78, responded that if federal judges, including Supreme Court justices, are appointed for life, they are insulated from political pressure. Basically, if you have a lot of people breathing down your neck saying that they're not going to support you for re-election unless you get certain things accomplished while you're on the bench, you're probably not going to be making decisions that actually reflect the Constitution, but more reflect what your political sponsors believe. In that case, the judges are probably going to act selfishly and do what benefits the majority because that's where their votes are going to come from. Since they don't have to pander to the majority for re-election, they can focus on protecting minority rights against the will of the large majority. In the United Kingdom, the power to protect rights is more dependent on Parliament than it is on the judicial system, and UK courts cannot strike down primary legislation. In Canada, there is a specific clause that allows the federal government and also the government within provinces to temporarily override certain rights, which really just weakens judicial protections. We don't have that in the United States, which is why the judicial branch is often seen as a last resort for people looking for help. The federal government can't really do anything about it. The features of our Constitution really set us up well for protecting minority rights. Now, that's not to say that the United States is fair to all people in all cases, but it does mean that there are safeguards to ensure that tyranny of the majority can't get out of hand, and there are things that we can do as citizens to make sure we're protecting minorities. I hope you enjoyed learning about our Constitution and how we protect minority rights. Personally, I think it's one of the coolest features of our government. Thanks for watching!